Good day, afternoon, morning, night, midnight. I hope everybody's well. Not legal advice. Please like, please subscribe, please share, please comment, please show your pets. Today, I'm going to be talking a little bit about the Kramer, GTII, and MMTLP, a little bit about each. But of course, before we start that, I wanted to go over three quick things. Why did the accountant hire, or even better, why did the accountant have to wait in a long line for a cab? Obviously, they were deferred taxis. Now, this is from one of my sons, and we have alternative punchlines. So I'll let you decide which one you like best. What do you call the disease of people who drink too many carbonated drinks? He said physies. I said physitis. Which one do you like better? And last but not least, what do you call it when a piece of graphite and a diamond go out for dinner? Carbon dating. Anyway, getting into, first I'll start off with the Kramer. So Kurt Kramer, again, Kurt with a C, don't trust him. The SEC went after him, filed an action in the beginning of May. So technically, and under federal rules, you have 21 days to respond to the complaint. That could be extended by stipulation and approval by the court, often is. So what will happen after the lawsuit's been filed, they get served, so the documents literally provided to them. They have 21 days to respond. They could either respond by answering the complaint. So you look at the complaint, depending if it's verified, depending on what jurisdiction is, you might have to respond to each paragraph of the complaint, or you may be able to respond to almost the entirety of the complaint, depending upon how it's framed and where it's framed. On top of that, so that's one way you can do that. And then you'd also assert whatever your defenses were. You can assert affirmative defenses, they're called. So in an answer, you answer the complaint and you assert your defenses. Alternatively, and often is done, it's done for multiple reasons because it might lead to the conclusion of a case, but often it delays it and it limits the claims. They could file a motion to dismiss or a motion to strike. And again, then there would be a briefing schedule. If they filed that, then the SEC would have a chance to oppose it. A chance to oppose it. And then the moving party, being Kramer in this case, would file a reply brief. There'd be a hearing. The court would then either say the complaint was okay or not okay. If in fact the complaint was not okay, usually they still give an opportunity to correct any deficiencies. So kind of that's the pattern. I will certainly follow the litigation and kind of keep you apprised of all these procedural elements. Now, it's important to kind of look at that there's an allegation that there's an excess of $75 million in profit that were made on the transactions between 2018 and 2023 that Kurt, with a C, engaged in. And again, that's the only ones we know about were found, even though on two prior occasions, apparently they worked out a settlement where they copped to doing the same thing. And again, that's acting as an unregistered securities dealer, I believe, is the main action, although that could expand. So $75 million is a lot. So in the prior deals they disgorged their profits. If they were to work out a deal here and had to disgorge their profits, we're talking about $75 million. Could they do that? Would they do that? Could they do it on a payment plan? I'm somewhat skeptical of that because of the large amount of money. So will they fight it or walk? That's kind of their choices. They could just literally close down their shop like the accountants Borgers just agreed to. They agreed to a fine, I think it was $12 million fine and a $2 million personal fine, and they basically shut down shop. So could they do that? Really depends on how much money they're still making and what their interests are, or if in fact they're interested in doing other things in the meantime, disguising what's gone on, etc. But I don't know. So in the prior occasions, they negotiated. So will they go ahead and negotiate it? I don't know. pure speculation on my part. The fact that they had two prior incidences where they basically admitted to the allegations suggests to me that there's probably hundreds that they did not admit to or haven't gotten caught on. It's, to me, it's like when you're out and you get a speeding ticket, that ain't usually the first time you've been speeding. So as to Kurt with a C, I believe this is likely not the first time he engaged in misconduct. And I think also what will happen is if you engage in discovery, during discovery, you're often going to be open and find other facts or strategies that might be subject to more scrutiny. And we don't know that. It won't be the case till we get down the road. Now, it'd be interesting. I'm not in New York or Texas. California, unfortunately, does not permit it. But perhaps because there's 325 microcaps that were included, but only 3 that were named. I think there's 3 that are named in the complaint. Perhaps somebody in those jurisdictions could go into court, file a petition to get the release of those 325 microcaps for the other shareholders. Just something to think about. So there's a lot of money going on there. Because of the amount of money, would the DOJ be interested in? Could this be a racketeering case, a RICO case, in other words, or a stock manipulation criminal matter? Perhaps. And if it is such, and one of these scumbags, and you can name whatever scumbag you can talk about, goes to prison for a minimum of 10 years, I think that would be very helpful for market ethics. You would see a lot of cockroaches and rats scurry away. So that's where the Kramer matter currently stands. If in fact it's resolved, we'll find that out. We may not find the terms if there's a settlement. But again, because of the large amount of profit, I think it's going to be a difficult case to resolve. And I would not be surprised if Kurt, with a C, spends a lot of money in legal fees trying to hide whatever has gone on. If in fact there's anything that's gone on that's not proper. Just my opinion, of course, all this. All right, GTII. I notice it's moving with the movement of the other stocks that are moving like GME, but very little. I know yesterday there was a PR that came out. I did not comment on purpose. I wanted to let the market decide where the stock was going. But there was a PR came out from GTII where they congratulated themselves on replacing their auditor. And the new CEO, Mr. Abari, was very effusive in his praise for management having acted so fast. Now, just understand, again, sequentially, they replaced the auditor who they put in place March of 2023, just prior to the downlisting, who did 2 years of financials and was banished by the SEC. So they can't work anymore. So it wasn't like these guys had a choice. And just to put it in context, David Reichman was the CEO, the CFO, and the chief accounting officer with a tax specialty and had run a tax practice, who chose Borgers, who's the biggest scumbags, obviously, because they're out now. So it's interesting that just a month before the downlisting, which was somewhat disguised by being put out in May after the dividend, that these auditors were banished. So I don't think that Mr. Rabari should be congratulating anybody for replacing the auditors. Now, what was interesting is they reaffirmed the financials, but with a reservation of rights that they go after somebody. I don't know what that means. If the accounting was bad, then Mr. Reichman probably knew about this stuff in light of his titles. If the accounting is good, all that establishes that 2023, they looted the blank out of this company. So either way, I don't think it really is helpful, and the market reacted as such yesterday. I'm dismissing my own lawsuit, but I'm getting involved in another one against GTII, again, with the intention of getting rid of the board, to banish the board so we can get rolling again. And I understand all the issues with regard to the squeeze and whether there's a business, but I'm continuing to maintain that there are literally dozens of suitors, or I've been told by different people who don't have communication with each other that there are many suitors who are interested in GTI because of its dedicated shareholder base and because of the concentrated short position. Many, that's what's believed, because otherwise, why would anybody have any interest in GTII? This is my opinion. With this board, why would you be interested? But because of the dedicated shareholder base, and because of the concentrated short position, apparently from the DTCC, there's others who are interested. Maybe they're wrong, but there are plenty of them that are interested. So those who assert that it's only a short squeeze opportunity, notwithstanding the business, I just disagree. I think it could be a short squeeze candidate based upon what happens in Alpine. I checked today, by the way, May 14th, and the appeal in DC is still not decided, and there's been no further movement in Utah. We're just it'll take some time, but there's no change in that regard. And some people think that based on action in that, there will be movement and perhaps a short squeeze. I'm looking for revenue, and I know others may not be, but in my position and based on discussions I've had, there are plenty of suitors out there who would step in and bring revenue to GTII. And I guarantee you, I'm not going to guarantee you, but I would expect that if there's revenue from GTII, that all those shorts would be frightened and would cover. That would make logical sense. So that's what I expect. Anyway, but in the meantime, I'm dismissing my lawsuit. I'm joining a different lawsuit. And anybody out there who has an interest in joining with me in an action, please reach out to me. And especially if you happen to be, that applies to anybody, but especially if you happen to be a large shareholder, please reach out to me if you want to get involved. And we're just talking about going after the board, getting rid of the board, etc. Hopefully getting the board to return shares. So please feel free to reach out to me if you'd like to get involved. And I don't know how many people I could accept, but I've had people reach out to me who had interest. And again, sometimes it makes more of a impact if it's a super big shareholder, but I'm happy to work with anyone. So please reach out and contact me. And again, today, somebody new told me that they believe they could get a deal done with GTII to bring in revenue. Today, told me. Somebody else knew today. So I realize there is a short squeeze possibility, etc. We will see how that works out. We know Alpine, we know the Kramers, which we'll keep you apprised of. But I think a business deal and revenue will do it. I don't really trust management. I don't think that has anything to do with whether there's going to be a squeeze by Alpine or not. But I do believe the departure of management will be a great event and catalyst for GTII. So that's my view, my opinion. Last but not least, MMTLP, arbitration scheduled next month. You all know two of my witnesses, but I can't disclose them yet. But I will tell you as soon as I have to disclose them, and there are two, I think, knowledgeable parties who will be able to present, along with myself, a coherent picture. Now, it's May 14th, and we are still arguing about getting rid of the main arbiter. Main arbiter, I haven't disclosed his name, but I'll do that today. Main arbiter, who I think is completely inappropriate. I would never use him, my opinion. And everybody who happens to come across him, I've given you my fair warning. Robert Sussin, Sussin. It's an attorney. He, just recall, so in this arbitration, I've kind of gone through the steps. So we went through what is discovery in this matter, which is very limited. Additional discovery where I sought share count, witnesses' names, documents in multiple motions, all turned down, no hearings, no reasoning, without consideration of the claims. I've learned recently, after I sued the arbiter, that he appears not to have a real practice other than arbitration, is using or appears to be using a false address with no real ongoing litigation experience, seemingly inconsistent with his disclosures, and he's over 80 years old. And so I did get somebody from the general counsel's office of FINRA did reach out to me to verify that I had served the complaint on him. And there's a lot of reasons, I think, at this point in time that this gentleman needs to step down. It's back in the director's hands. To this point in time, the director's been extremely unhelpful, but I hope and part of the process I've tried to describe is to tell you how and show you how corrupt the FINRA arbitration practice is. And that's why I'm kind of disclosing it. I'm not a glutton for punishment. It's not fun, not at all. But I wanted to kind of demonstrate what the process is like. So we are just pre-trial, but we haven't got the discovery we needed. And we're back in front of the director with a very compelling argument as to why this arbiter should be removed. And if nothing else, we've made a record for the trial court to present about the unfairness in the process, and if necessary, to the Ninth Circuit Court of Appeals do the same thing. I knew that when I started, that was possible, and we'll see how it plays out. Anyway, so that's May 14th. I expect sometime this month we'll get some type of a ruling from the director, and then we'll see if that impacts the trial date, which I believe is June 17th through 20th. That's when it's scheduled for, and I'll keep you apprised. So again, talked about the Kramers. Hopefully they get banished. Talked about GTII. Talked about if you want to join litigation with me, feel free to reach out to me. Talked about the MMTL arbitration. To all you out there, be well. Talk to you soon. Take care. Have a good day or afternoon.